Hello, everybody, and welcome back to our continuing series on the COVID-19 virus and workers' compensation. Today, we're going to talk about psychiatric injuries. I want to introduce, before we get started, though, my most august companion and speaker, the large-headed Adam Dombchik. Say hi, Adam.
After last week's presentation, a couple of my colleagues listening in came to my defense and said my head was not that big. So just for the record, I want to note that.
Your head is not actually that big, but the picture juxtaposition with my head is, a little bit funny to me. But
it's the only misleading slide in the whole presentation, I must say.
So here's what we're about. I'm a defense attorney. I actually run a defense firm, which has gotten pretty big. We have offices all over California, and we've expanded from workers' comp into employment, immigration, insurance litigation, and soon to come Wilson Trust. I don't know if you knew that or not, Adam, but we can do your will for you. So we're pretty proud of it. That's pretty awesome. And I'm also the author of Sullivan on Comp. This is a Sullivan on Comp presentation. If you're listening to this, this is probably not the first Sullivan on Comp presentation you've ever heard. We're making it available not only to Sullivan on Comp subscribers, but to the whole world due to the extreme nature of the COVID virus, but it is a Sullivan on Comp presentation. So when I talk as the author of Sullivan on Comp, I really try to maintain some neutrality. Although Adam, you're so disgustingly liberal on every point that I'll probably have to argue with you and show my defense orientation in that process. But Sullivan on Comp is written from a neutral perspective. It's a comprehensive treatise, and it tries to consider all points of view, all issues, and all potential actions that people would take. So as we go through the presentation, we put the Sullivan on Comp section on the bottom of the slides. So if you want to learn more about any one subject that we're discussing, you can just go to Sullivan on Comp and check it out. Now, Adam is from Gordon Edelstein Krepack, a nemesis on a lot of our accounts, and we fight with them bitterly. Of course, we trounce them routinely. Not really, it goes back and forth, but Ab and I, for some reason, have always gotten along pretty well, and we've spoken together over decades on many occasions. So I've been happy. He used to be the president of CA, and he's a real smart dude and very thoughtful guy. So I'm happy to have him to speak with, and we tend to speak well together. Don't you think, Adam?
I think we do, and I appreciate the invitation. It's good to be back. Thank you.
Good times. I also wanted to advertise our book. We wrote a book on COVID-19. If you printed it, it'd be about 200 pages long. It is freaking awesome. It is. It's got the answer to every question about COVID-19 for employers and carriers and TPAs, or really anybody involved in this mess. It covers workers' comp, immigration law, and employment law in depth. So like what we're talking about today, there's a few sections covering that. It's updated constantly. We're leaving it online only. We update it every day almost with new sections or new thoughts or new information, or modify it as the news develops. So if you go to our website, look at it, you can put it on your desktop, and you'll always have an answer to your question for COVID-19 guide or book. It's really cool. What we're doing, it has a context. So let's see, this is actually number 9, I think, because we started it off talking about employment law and workers' comp, and we went through a lot of issues, and then we got real specific, talking about when to provide the claim form. And man, I've had more questions about that than anything else from the world and our client base, both at SOC and the firm. And Adam joined me, and when we started talking about whether or not COVID-19 could be work-related, and we talked about that, and then we talked about the basic rule, and then whether it could interplay with non-industrial conditions, which of course it can. And then last time, I don't think it's on this slide, but we had part 8 last Friday on an emergency basis because of the emergency order issued by the governor, and we went through that in some depth. So today we're going to continue, actually complete our discussion about when COVID-19 is work-related, I think, at least the basics of it, by talking about the psychological aspects of it. And that's a big part of it. When is the psychiatric? I mean, there's a lot more to COVID than just physical injuries or having COVID, right? I said this before, but a few seminars back, I was stupendously stupid, and I lacked insight and said, well, what's the big deal about COVID? You know, most people are just going to recover and go back to work for this few cases that are more severe. They could be making claims for that, but there won't be too many other claims other than that. And that was just ridiculous. I thought about when it struck me, you know, what about all the people that are claiming psychological injury? Then I realized I started to realize the depth and severity of the rash of claims we're likely to see. What if you go home? You know, what if you go home and you don't like it at home, and you're stressed at home, and your coworkers aren't there, and you develop psychological problems? I mean, what if you get COVID? What about the psychological impact of that? What if, you know, you develop psychological problems because someone you love or your coworkers have COVID? I mean, there's a lot of different scenarios. And as we go through this, you'll see that Adam and I are going to have a lot of fights about this. There's lots of different things. I mean, is it an actual event of employment, going home, or other consequences in your employment relationship? Are these, or actions that the employer takes, are these actual events of employment? First of all, are they predominantly caused by work? Second of all, and is it on the employer since it's ordered by the government? Is this an employer action, and does that matter? Could an exception apply? Could it be a violent act? And then there's all the possible defenses. The good faith personnel action. Is this a personnel action, sending people home from work? And then what about the 6-month rule? Does that still apply in the scenario, or would it apply? And we don't have it on the list here, but is this a physical injury? Is COVID a physical injury such that the rule prohibiting psych add-ons for physical injuries would apply? These are all the issues we're going to talk about today. There's a lot of them. And in most cases, we have an idea as to what the law is going to be and how it's going to play out. But Adam and I are going to disagree, take different positions when we get into court on this. So, but before we get going, we always like to give you the latest updates on COVID. We got a few things going on, not like last week. Last week we had the governor issuing an emergency order, so that was a big, fat, hairy deal. And of course, the landscape's changing every week. But you know, this week is not too much in the last week. That, I mean, it would be something. It would be remarkable if it was a regular week in workers' comp, but it isn't. So one thing is that the WCRB has announced that they're going to discuss the potential costs, and they're going to research the potential costs of the governor's recent executive order establishing a rebuttable presumption, right? So we put the website up here. You can look and see what they're talking about. But remember, they ran the numbers, and they found that if there was a conclusive presumption, it would be billions and billions added to the system, increasing the cost of the system by something like half over again, depending on how many people got it and how severe it was. We don't know. They're going to actually try and run numbers and see how much does this governor's order cost if it's left in place permanently. There's a lot of legislation winding its way through the legislature to try to keep the presumption in place, but we don't know how much it's going to cost the system.
I mean, I appreciate that they're going to make efforts, but I think that we cannot be reactionary to what they determine. No one really does know. And a lot of the cases that are reported are people not actually in the workplace that have had the most severe injuries. So, you know, let's put the brakes on this a little bit. Let's evaluate it. Your excellent session on the order last Friday, Mike, should have people quite aware that it's a limited period of time in which the presumption applies. So yeah, let's study it. Let's talk about it, but let's not overreact to it.
Well, I don't know, man. I mean, they're going to come up with something in the legislature, and it being a Democratic, you know, majority, I got to think the governor's going to sign something that will replace the bill. I don't agree ever with overreacting, but it's a lot, dude.
I didn't say it wasn't a lot.
It's a
In
lot.
any
It's
event.
going to be a lot no matter what it is. I mean, but it's dependent on how many cases actually come into existence too, right? So we'll see. Anyway, so they adjusted the fee schedule to conform to the additional Medicare fee schedule for telehealth. They wanted to allow telehealth to happen, so they revised the fee schedule so that they could get through there. So the claims administrator should adjust the payment systems in light of it. I think it's for services rendered on or after March 1st, 2020. We have a fee schedule for telehealth, so that's kind of a big deal. And then we have Governor Newsom again. He's a very active fellow on this stuff, isn't he? He recently, I think he has 6 phases for restoring the economy. And the first phase is kicking in here. He's going to allow people to go back to work, to offices where they can't telework, malls and strip malls. You can go to get outdoor pickup there. Outdoor museums are going to be open again. The guidelines themselves are available on the site that I have here with the government. This is in our book too. We update it all. It's still up to local governments to determine whether they're ready to move into the next step. So we're going to see a lot of variation. Next week, Adam and I are taking a break, and Eric DeWames and Janie Nethery. Eric DeWames is our managing partner for the employment law section, and Janie is the executive director of our firm, making the return to work plan. They're going to put on a webinar about the return to work process, which is on everyone's mind, and what we need to do and what we need to be careful about. So that's going to be the week out next week. So tune in for that, but you won't get to hear my lovely voice or Adam's. The week after, it looks, I talked to Jake Jacobsmeyer, who a lot of people know. He's a really brilliant guy. I hate his guts because he's a competitor, but I got a lot of respect for him. He's a nice guy and a friend. And he had COVID. And it's quite an odyssey. It's a hell of a story he has to tell. And I'm going to interview him the week after. And we're going to talk about, he's been listening to my webinars, and he's got some ideas and further points, things I missed. And we're going to talk about that. So I'm excited about that webinar too. So we're going to keep it up, folks, and until we're done. But this
Just a shout out to Jake. Hope you're feeling better, Jake.
He is feeling better.
Good.
It took him 3 days to get his mind fully back, but his commentary, I was talking to him and he's sharp as ever. So he's in good shape. Okay, so let's get to what we're here to talk about, which is psychological injuries due to COVID.
Hey, Mike, just one other point. I'm sorry, Mike, just one other point on latest news.
Good.
People should stay tuned. There was some emergency regulations, very brief, just about service of medical legal QME reports that were submitted to the Office of Administrative Law last Friday, and I believe they, with whatever changes they might accept as of yesterday, would come into effect at the end of this week. So that's on the DWC website, and people should just be aware of those changes in the electronic service rules for the QMEs.
Yeah, well, we had discussed them in some depth in a prior webinar, I think, and it is described in depth in our book, and we've updated the book because they did change the proposed regulations for QMEs. There's a whole new process for virtual QMEs, and I think they took away the fee schedule, but it's in our book and you can look it up for the exact, I think Friday, they might actually be in effect, the emergency regulations. Is that right, Adam?
That's my belief.
Yeah, so, here we go. I think people are kind of operating under the regs as it is now, but if you're a practitioner, you better be familiar with that stuff. And when we have a final version, I think it's going to be about the same as the original, but we'll update you, of course, with any changes, probably in a red alert. We haven't had a red alert in 2 days to our subscribership, which is amazing. We've done more red alerts, which is we send an email saying, hey, this happened today, better know this. It's called red alert, and we've done more of those in the last couple of weeks than we've done in the last 4 years, I think. Anyway, so stress on the job. Okay, so we have stress. Are you feeling stressed, Adam? You look a little stressed.
Terribly.
Are you?
I want to put on the best presentation here today. It stresses me out a little bit.
Yeah. Is this a work-related activity, what you're doing now?
It's absolutely arising out of in the course of something.
Couldn't it be characterized as recreational? Of course,
if it doesn't,
recreational in a way.
If it doesn't go well, there'll be a violent act or two, I'm sure.
Okay. Well, anyway, so we have the go home order, right? Except for essential workers. And as a result of that, businesses had to change their business practices, and that affected their employees, and the different things that they did could be claimed as psychological injuries. I mean, some people got laid off. Now, the idea of filing a stress claim when you get laid off is not a new one in workers' comp, is it? Right? And of course, there's all these defenses in place, post-termination claims and all that. Does that still apply, to COVID workers or layoffs because of COVID? And then some employers had to implement new technology. Right now, I'm on a Zoom meeting. I'm looking at Adam's face because I couldn't do. This is the first one we've done actually from our homes. We didn't have to come to the office for this one. So I want to thank Mike Bell, who runs Sullivan on Comp, and Ian, who helps him, and they did a great job. I'm able to change the slides and talk and see Adam at the same time. Of course, all you folks can see other slides. But anyway, there's a lot of new technologies, right? So that stresses you out. I mean, I'm trying to learn Zoom and go to meeting, and I can't function very well. I'm an old dog. How am I supposed to learn this stuff? So that can be stressful. Some businesses that are essential told their employees to maintain physical distance from each other and from customers. How does that make you feel? I was walking into the office today because my printer broke here. So I went in and I got a copy of the presentation because I like to have a hard copy. And one of my lawyers was going in, and we kind of didn't know how far we should be from each other, and he was wearing a mask and I wasn't. And, I mean, it's weird. There's no human contact. It doesn't feel good. It's stressful, and so much is going on. There's a lot of adrenaline going on. The sustained adrenaline over many weeks is not good for you. So, I mean, what about that? Are these valid psychological claims? And there's others employers who've had their employees working different hours, staggering shifts. I mean, we've been burning it hard. What about that? What about people that don't have time for lunch, you can't sleep? And, all of these different scenarios need to be analyzed. Now, I want to say here at the start that, these cases, when they get to litigation, are going to be heavily fact dependent. It's like a obstacle course, and we're going to take you through it today. But the ROLDA analysis, a lot of you are probably familiar with that. Adam, did you not turn off your phone before we started the webinar? I can hear it ringing in the background.
This is very stressful. I work at home and my wife and I share an office. Even though she is quarantining the dog and the kid upstairs, her work phone is still in the office. So I apologize.
I see. Well, you tried to turn it all off, but you just couldn't get it going. Anyway, so getting into it, liability for a psychological injury. The coronavirus doesn't change the law. The law is the same. So if you have a claim for psychological injury, then the law as it applies for psychological injury, all 32A.3, all the defenses, the predominant cause standard, actual events of employment, that's all the same. The question is, how does it apply? The labor code says that a psychiatric injury is compensable. We're only a few states that even allows for compensable psychological injuries, as I understand it. Although last I looked into it, it was several years ago. I think we're like one of 8 states or something. Do you know, Adam?
I don't know the number.
Yeah. Anyway, in order to establish, now I want to say up front, it's not enough to be stressed out, right? You have to show that you have an actual psychological disorder under the DSM-4. And they have standards, lists of symptoms that you have to have in order to meet the definition of a disorder. And I think that's something that practitioners overlook a lot. They don't question doctors about that, especially on the defense side. If you have an adjustment disorder, which is the most common type, by definition, it ends within 6 months, so there couldn't be any permanent disability, you would argue, right? So there's that, but nothing changes with that with coronavirus too. So being stressed out, being sad, being lonely, that's not enough. You have to actually have a psychological disorder that needs treatment. Adam, you're nodding your head.
Well, that's important. I mean, I get calls quite frequently, even before coronavirus, people that are upset about what's going on in the work environment. And we have that exact conversation, Mike, about to what extent is there likely to be a permanent mental illness? And do they want that label, for lack of a better word, to carry with them on their next circumstance? So I do think from interviewing someone and determining whether this should be part of their COVID or coronavirus claim, you still have to ask the same questions and make sure it's the right remedy for that particular person. It's not a catch-all be-all for everybody.
Right. And Adam, I respect you for that, because there's so many applicants firms that just add sleep, sex, and psych to every claim and figure it out down the line, right? And I don't respect that. I don't think they serve their clients well by doing that. We know who they are. We don't respect them as lawyers because they're not really lawyers. They're just processors, right? So to use that kind of judgment and discretion, when Adam says, I'm filing a psych claim, you better pay attention because he's not kidding, right? He's on the defense side. Doesn't mean we're going to agree with it, but it's, we're going to pay attention. So In order to, the basic standard is, and this is different, right? This is part of the 1994 legislation. I remember when it came out, because everyone that got fired was filing a claim for psychological injury and they would win. And the thing is, even if they lost because they couldn't establish that they had a disorder, all the med legals get paid, right? And so it was just a terribly abusive system. So as part of the reform in 1994, we saw the standard of proof change for psychological injuries, and we saw the special defenses under 3208.3 enacted. And we're going to discuss that, how that works today, because that's why psych injuries are special. In order to establish a psychological injury, you have to demonstrate by preponderance of the evidence, that means more likely than not, 51%, that actual events of employment were predominant as to all causes combined with psychiatric injury. Now, Adam, my friend, my competitor, what does that mean? Actual events of employment. I got to tell you, I interview lawyers to work for me, and I ask them questions about the law, and I ask them, what does that mean? Actual events of employment. How is that different than just work related? 9 out of 10 of them had no idea, and I didn't really have an idea until I wrote that part of the book. What does that mean?
Well, the next slide is going to talk about it, but the funny thing about the law on workers' comp is just how often the legislature provides us with a standard and then fails to give us any definition. And this is one of those circumstances, is it not, Mike?
But look at it this way, Adam. If they didn't do that, they wouldn't need us.
I'm thankful every day. Hopefully the legislature is not listening.
It is not defined in the labor code. It has been held by the Court of Appeals that a physical injury can constitute an actual event of employment for the purposes of this statute. So what that means is if you get coronavirus, assuming that's a physical injury, that if you have a psychological overlay, that would be an actual event of employment. So we know for those people who have COVID, and if it's established as work related, that would be a legitimate basis for a claim of psychological injury. So assuming they could show a disorder. So an employee who contracts COVID on an industrial basis is going to bring their psych claims as long as they can show that the COVID-19 was predominantly caused by the psychiatric injury. So it works the other way too. Now, what if it's not directly connected to a diagnosis? What if it's just a psychological conditions caused by the stress of all the different things we just talked about, rather than the coronavirus itself? Is that an actual event of employment? I'm leaving you hanging. Well, the main case on this is Pacific Gas and Electric. This again was a Court of Appeals case, so it's serious. And it was held there that some of them are and some of them aren't. Okay, what Pacific Gas said is that broad societal events or trends do not satisfy the requirement. Okay, because they're not events which arise out of the employment relationship. So worrying about the well-being of the company, worrying about how the stock is doing, worrying about whether the company will go bankrupt. That's not an actual event of employment, because these are things that just happen generally to the business. They don't count. Whereas if we didn't have that term actual event of employment, they might be considered work related if you got stressed about them. See, the term actual event of employment is designed to limit the scope of workers' comp for psychiatric claims. That's why it's there. So what that means is some things that are connected to work are not actual events of employment, even though if they were connected to work in some other way, if it wasn't a psych injury, they might be considered that. It's a limiting factor. So they determined that generalized anxiety over one's future in the company, struggling to survive, fear of losing your job due to management strategies. I don't like what they're doing, I'm afraid I might get laid off. I'm afraid I may lose my job. What's going to happen to my family? Not an actual event of employment. We're going to outsource jobs overseas. We're going to start, using independent contractors in some way. I'm worried about that. What does that mean for my job? Not work related, not an actual event of employment. These are not actual events of employment. Corporate downsizing alone cannot reasonably support an award of benefits, because, and the quote says here, allow employees to recover benefits for psychiatric injuries caused by this type of stress would subject employers to virtually unlimited liability. So we're going to have to downsize, not an actual event of employment if you're worried about that.
Mike, when I interact with someone and we have this conversation and I'm trying to assess this, I kind of work backwards. I mean, I start with what is their actual employment? What are their responsibilities? Who do they interact with, and how are their responsibilities communicated to them? And I kind of think of like a wheel with my clients sort of in the middle and looking at the spokes coming from the different responsibilities that they have. And if something is sort of not within that circle, if it's on the periphery, it's probably not going to be an actual event. It would be the questions I would expect you to ask my client in a deposition, and I need to know the answers and understand the facts to know if we have a case that's passable. So this is a super important case to know and understand, and I think these two slides summarize it excellently.
Yeah, here's the next one. What happened actually in Pacific Gas is that the court said employees' stock losses could not support the award because investment loss is no different from that experienced by the general investing public. And also in that case, the employee had said, I am concerned over the future of the company, and I'm concerned over my retirement funds, right? My 401k, what's going to happen to that? Not an actual event of employment, but they did say that what happened in the case is the employee was reassigned to a new position. And in that new position, he had to interact with irate customers. Well, you can see that in the COVID environment, right? All the worried people calling, all the angry people calling, all the people that disagree with what you're doing as a business calling, all the other employees talking to each other about, he was moved into a new position. They said that could support an award. That wasn't his movement to a new position, which caused him stress.
We've seen some of these stories nationwide, right? There's been reported stories of physical violence for wearing a mask, not wearing a mask, being confronted by customer service people, and customers not being happy with those confrontations. So it's a real thing in the context of coronavirus.
Yeah, and you don't have to necessarily be moved into a new position to encounter those things. But in this case, he was moved into. Now, if somebody had not been moved into a new position, but they were encountering this sort of thing, like irate customers, would that be an actual event of employment? Maybe, but it would be, this certainly was, because he's reassigned to a new position. That was an event, right? That happened in his job, so it was work related. And so he won the case. The applicant in Pacific Gas actually won the case because it was found that he was moved to this new spot. He did get stressed. He did have a compensable psychological injury. He won despite all the things about how this is not an actual event of employment. At the end of the day, he was able to demonstrate it. But this case does illustrate the fine points, the distinctions that you have to make in individual cases, and how incredibly dependent upon the particular facts of the case these things are. So, how does this apply to coronavirus? Well, you can see it. It's pretty obvious from what we just said, right? So if I'm concerned about my job, we're all concerned about our jobs. Everybody is in this economy. What's it, 30 million people unemployed in a month? If you haven't lost your job, then you're worried about losing your job. If you're a business owner, you're worried about your business. But that's not going to be considered an actual event of employment, and therefore those claims will not be compensable. It's going to be really interesting when we get into a preponderance argument. I'll wait till the next slide, but I was going to say, weighing those concerns versus others that might be considered actual events of employment. But anyway,
Mike, I heard a story, and I think it falls under the conversation about actual events, and it's just awful. A woman contracted the virus on the job, brought it home to her husband, who contracted it from her.
mm-hmm.
She recovered. He passed away. Do you think her emotional reaction to that consequence arises out of an actual event of the employment?
Well, as a defense attorney, I would automatically say no. But moving into
but of course, you would feel bad for her as you were saying no, right?
Well, yeah.
Of course. Okay, go on.
Who would feel bad for someone's husband died? Unless the guy was beating her or something.
Oh,
I don't know. I don't judge other people's marriages, Adam. I'm not like you.
Back to my question. After your initial defense reaction, what do you think?
Well, what you have there is a multi-step causal analysis, right? I mean, there's multiple causes in a row, and it goes back to law school and proximate cause and intervening cause and all those things. That's going to be a really involved, that's a court of appeals levels case, I think, because what happens there is, the applicant says, well, look, but for the applicant having industrial coronavirus, the husband would have been infected and died. Therefore, him dying is a work-related incident. And then the defense is going to say no, because just because something is work-related, all of its effects are not necessarily part and parcel of that work-related injury. I mean, I can't think of a case where an applicant, let's say an applicant was really injured orthopedically and was in a wheelchair, and then they lost the marriage because of that. Would that be a work-related injury? Can't think of any cases directly on point in non-corona cases on that. I don't see you guys pushing that too hard. We'd fight over that.
Yeah, although, I have seen in psychiatric reporting, psychiatric reporters questioned on the person's reaction to a marriage gone bad. And I've heard them conclude, well, the marriage went bad secondary to all the things the person can't contribute to the household anymore because of their industrial injury. So I consider that to have some industrial nexus to it. So I can't think of a case per se, although I've read reports and been in depositions where doctors have come to that conclusion. And I wonder if when it got to the Court of Appeals, if the courts would be considerate of this terrible outcome. I don't know. I don't know the answer to the question. I heard the fact pattern just in time.
I love the way you frame that, whether the courts would do the right thing. Yeah. Yeah, whether they would have consideration for the poor and downtrodden or not.
I'm a true believer. I think that they will, I would hope.
Yeah. Well, the Court of, the appeals board is always liberal, but you never know what the Court of Appeals is going to do. It's a crapshoot. It's weird sometimes, and sometimes it's just stupid, But anyway, so I want to talk more about that when we get to predominant cause shortly, because I think the interaction between an actual event standard and a predominant cause standard is really interesting. But anyway, we do know though that, so while general concerns, worries are not going to be considered actual events of employment, specific changes in the workplace as a result of the coronavirus would probably be considered work related. So, a change in job assignment. We're now changing your job assignment. We are changing your work duties. Go work at home, or working conditions, or new technology. That would be claimed by applicants as work related, maybe with some success. And then what about working from home? I mean, that's really going to be the big one, right? Because everyone was sent home. So is that stress from working at home an actual event of employment? You're going to say yes, aren't you?
Well, we spent our last, sorry, I thought you were pondering and we're going to follow up with a comment, but we talked about other work injury exposures that could occur working at home and those liabilities in our last conversation. I don't see it any different with psychiatric. It's just a new and different environment. It can present new and different pressures, but the demands to get the job done remain the same. So I don't know how you ignore them just because the physical location is different. The physical location matters.
Yeah, I mean, but the devil's going to be in the details. Let's say that they can establish by sending them home. That's probably an actual event of employment, I would say, as a neutral observer. As a defense attorney, I would say it's absolutely not an actual event of employment. But the devil's going to be in the details, right? So if I'm deposing somebody on this, I'm going to be like, well, what was your environment like at work? Tell me about all the stresses. Tell me about all the conflicts you had with all the workers. How's your home life? Do you like your kids? Or not? Do you hate your kids? And I'm going to do that. So I'm going to try and paint a picture that actually they're much happier at home. I mean, there's no reason to be stressed working at home. This is an advantage. Many people would love to work at home, but they're not allowed to. So I would go deep on the facts and try to establish that, working at home wasn't stressful for them. I would say, isn't it a fact that you're really worried about your job, right? I mean, that's what's really stressing you out. The fact that you go home really doesn't have much to do with it. The fact is you don't know if you're ever coming back. I mean, you're telling me, is that stressful to you or not?
God, sometimes I forget you're a real lawyer applying the facts to the law. That's fantastic.
Thank you.
No, you know what?
If a lot of stuff like that.
I think you're right. If I had someone come in to me and they describe
We lost your audio, Adam. Adam, lost your audio. The next, you probably hit the mute button on the front of your microphone or something like that. Nope, can't hear you. I'll keep talking. You keep pressing buttons. So anyway, what if the stress is related to caring for children or family members while also working at home? So here you're at home, and you're not necessarily stressed because you're actually doing work at home per se. You're stressed because you have to watch the kids and work at the same time, right? So caring for children is pretty common. In fact, we have the homeschool situation. I'm seeing it in my own firm. This is not an unusual scenario. Now, if you're the defense, you're going to say, no, that doesn't count because this is about caring for your children, which is not a work-related activities. Or let's say someone else has a work-related, stay-at-home situation, and you're dealing with your wife or husband. That too can be questionable as to whether it's work-related or not. So we're going to have some fights over that one too. Should employers be liable for actions mandated by the government? Now, this is something I thought about and I was arguing about with my co-author, Sherlock. We thought about it a lot. And the point is that when someone's at home these days, is that an employer action which puts them at home? Or is that an action by the government? Because remember, the government ordered everyone that was not essential to go home. So the employers didn't order them to do that. The employer may say, why is it my fault that someone is at home when the government ordered me to do it? So they would say, this should not be considered an actual event of employment. It's an event that occurred because the government ordered it to happen. So that's going to be an argument that the defense makes. The applicants are going to say, well, yeah, the government ordered it, but the employers had to do it because of the coronavirus, and they gave the order to do it. This became the work environment by the decision of the employer. And so we'll go back and forth. But the main argument the applicant will make is that it doesn't really matter if it comes from the government or the employer. This is their work environment when they're working at home. And a couple of sessions ago, or maybe it was the last one, we talked about home as the second workplace and how anything that happens in the workplace is work related with the personal comfort doctrine. So the main argument is going to be it doesn't matter if the government ordered it or not. And there's a couple of cases on this that speak to that argument. I have them listed here. We got the Merced City School District versus WCAB Delgado. And in that case, there was the teacher was doing fundraising, and she was accused of fraudulent behavior in the process of fundraising this money. And the board, the grand jury came in and investigated her, right? And she got really stressed out because she was being investigated for fraud. Now, she was ultimately found innocent, or there wasn't enough to charge her, and they didn't proceed with charging her. And she said, I have a psychological injury case. And the employer said, look, this is not an actual event of employment. This is something the government is doing, not something we're doing. But they lost. It was held that it doesn't matter. It's still work related. It's still an actual event of employment. It pointed out that it was allowed, if not endorsed by the employer, the principal and assistant principal. It would be very analogous to what's happening now. Now, I note that this case and the case that I'm going to talk about next are both, panel level cases, which means that they're citable but not binding. So they're not necessarily binding on this argument, but we're going to mention them anyway because they show the mindset of the appeals board going forward. The other one is this Minyandu, I hope I'm saying that right, versus LUSD. And here, the applicant was arrested for workers' comp fraud and was acquitted for workers' comp fraud. And it was held these were the actual events of employment which could support a psychiatric claim. It's the same sort of thing that we see in the other case. It goes to the same sort of set of concepts that applies. So this argument doesn't appear to be super strong for the defense. Certainly it's going to be one that's going to go all the way up because the employer is going to make it in every single work at home case. So, I mean, if you look at both of them, both these cases, the actions at issue were not attributable to the employer, but to the government, but were still considered actual events of employment because they occurred in connection with and with the employment at the employment location. So, again, I got to tell you, this is an issue, right? We don't have a certain answer. We're just going to have to proceed. The next concept is predominant cause. Now, the standard is the applicant has to show by predominance of evidence that actual events of employment were the cause of the injury, right? So you have to show 51% causation that what happened at work is mostly what caused the psychological injury, and what happened at work is the actual events of employment. This is a different standard than anything else in workers' comp. We don't see this anywhere else because workers' comp is a no-fault system. In fact, we talked a lot in prior webinars about the 1% rule, where it's held that you can't apportion anything in workers' comp except permanent disability, including causation of injury, meaning that as long as the work is a contributor to the development of the industrial injury, that it's compensable. Any level of causation at all is enough. And we live with this in the workers' comp system all the time, right? We say, well, why should we have to pay TD? Most of the reason he's not working is because of blah, 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 and it's not the work-related injury. Or why should this could be considered work-related? It was only a little tiny bit of work contributed to it. Doesn't matter. But with psychiatric injuries, in 1994, they deliberately made a higher standard, and they said 50%. And I have this quote here. It is the intent of the legislature in enacting this section to establish a new and higher threshold of compensability for psychiatric injury under this division. So we're just going to have to see, how it plays out with COVID. So there's an exception, though, right, to predominant cause, and it's the violent act. If the injury is a result of a violent act, then the standard is lower. You don't have to show predominant cause. You just have to show substantial cause. That's different. That's not 50%. That's only 35 to 40%. It's lower than the prominent cause standard. So how do you show that there's a violent act, and would this apply in corona cases? We have a case here, which is really the lead case, I think, in this area. It's Wilson versus State of California fire. In Wilson, it was an en banc decision, so it is binding, and it defined violent act. If you look at this section of Sullivan on Comp 5.30, we discuss all the cases on violent act, and there's a lot of them. It's kind of like setting an extraordinary for the 6-month rule exception. It's all over the place. The board has held things all over the place, different fact patterns. But Wilson is en banc, so it's a good one to look at. And it characterized a violent act as an act that is characterized by either strong physical force, extreme or intense force, or an act that is vehemently or passionately threatening. Now, of course, what does that really tell us? You know what I mean? They're giving us a standard, but they're not defining it very well. So we have to look at the facts of the case to see how it played out. I mean, I think what they're trying to say is, look, something's got to happen that you would say, wow, look at that. That just happened. It's not enough just that your injury is really bad, right? Or that you're really hurt. So in Wilson, what happened was there was a firefighter, and he fought the wildfire for several hours. And during that, he was exposed to fumes and smoke from the fire, and and it was found that he did not sustain an injury from a violent act.
Mike, you know, the long line of these cases that deal with larceny and thereafter, I would just suggest if anyone is trying to assess violent act in the context of coronavirus or anything else, definitely check out your section. We did a seminar on this last year, and there's probably at least 24 cases that are very fact specific on this topic.
Good to have you back, Adam.
It's good to be back.
What happened? You press the mute button?
Yeah, I don't know. I didn't touch anything, I swear. But you know, all this technology, which works, is great. And when it doesn't, it really stresses me out.
Yeah, me too. We broke the internet with our first webinar and no one could hear us, and we had to go record it afterwards because we didn't anticipate so many people signing up, which was dumb. But yeah, it happens.
I'm sorry that happened. Glad to be back.
Yeah, okay. Anyway, actually, you know, without you here, it was kind of peaceful, to be honest.
Unfortunately, I lost a little audio too, so I was trying to read your lips, and whatever you were saying, it couldn't have been good.
Applying the violent act exception, you know, we're talking about predominant cause, right? And so the exception, how would it apply to COVID? And I'm thinking that it's unlikely that the violent act exception would apply to getting COVID, because it's not something happens to you, wham, right? It's not like that. It's more like you get it. There's not a particular act, there's an exposure and you slowly get symptoms. Remember, Wilson made the distinction between how bad your injury is and how the injury is incurred. Your injury can be really, really, really bad, like the firefighter breathed in smoke, right? But that wasn't a violent act, even though he was really, really messed up from it. It doesn't really matter how messed up you are. What matters is what happened, and it could be considered a violent act. So even in that case, it was held it was not a violent act. So it's a relatively high standard to get to the violent act exception. It doesn't seem like, to me, and I'm sure you'll argue, Adam, but that case Wilson seems very analogous to what might happen to somebody if they get COVID, even if they're on the front lines.
Yeah, I think you're right. I probably would tend to agree on that. And I think part of the problem with this particular virus is we're still trying to figure out all the ways it's transmitted. We don't know all the ways it's transmitted. And I think you have to trace the transmission to probably prove up how some strong physical force or extreme or intense force or, you know, was the cause of how you contracted it when you did.
Yeah. Anyway, you know, I think it's going to be really interesting to see how predominant cause interacts with actual event of employment standards. So let's say that you're really stressed out from, maybe I'm going to lose my job. Okay, it's not an actual event of employment. So it actually becomes a weapon for the defense, right? Because we could say, look, this was the cause of injury and it's not an actual event of employment. You being stressed out by working at home, an applicant in deposition is not going to know that unless he's really coached by the attorney. So I'm going to say, aren't you scared about losing your job? You know, didn't that suck? Did you worry that the employer might go under? And now I try to establish that as a predominant cause, right? You parse out what isn't an actual event of employment and emphasize that on the defense and downplay it on the applicant side. And that's going to be the fight.
Yeah, and it goes back to the point you made about the diagnosis. I mean, is this a anxiety, depression related circumstance? Is this a post-traumatic stress disorder from something that occurred during the course and scope of treatment, let's say for the coronavirus? I interviewed somebody a week or two ago who was ventilated for about a week. And even before coming to see me, although the person was improving and better and back to work and still having some various residuals from the condition, what led her on her own to seek some therapy was she was having nightmares about being ventilated. She wasn't ventilated, but for the coronavirus. And if she has a PTSD diagnosis stemming from that care, I think she's going to get predominant cause despite your exact and fine questioning and trying to plant other explanations.
That's an excellent point. It's an excellent point. Like it's devil's in the details, and the psychological diagnosis is going to have a lot to do with that. I mean, what's that I always say? Reason backwards from pathology when you look at a case. Look at what's wrong with the person, and then you can start looking at what caused it, right? Anyway, it's going to be really interesting. It's easy to imagine, though, like you're saying, the frontline workers being able to claim PTSD. So we're going to have to see. It's going to be frickin' slugfest. And I'm kind of glad for one. I'm tired of this environment where all of my clients want me to do is settle cases within 90 days. It's getting boring. I want to be a lawyer, you know, and I'm going to get my chance.
I will play a little devil's advocate. As you know, this is different than the physical injury cases. You do have to tread cautiously with the applicant. You have to make sure that this is the right remedy. They might be able to meet all these standards. They might be able to prove up this case, even in the face of your tough questioning. But this just might not be the right remedy for each individual person, and that really has to be assessed before it's pursued in the comp arena.
Fair enough. Okay, now we move on to the defenses. So we've looked at how you establish a psychological injury, but what about the special defenses? And there's a number of them. The big one's the good faith personnel action, and these are the 38.3s. Good faith, there's the post-termination, there's the 6-month rule, and then there's not 32.8.3, but the limitation on permanent disability for quality site claims. And so how is this going to work out in coronavirus land? Well, the first one, the big one, is good faith personnel, and that says that no compensation is due, even if you have a psychological injury. It is an actual event of employment, and it is, all the standards we just talked about are met. You have the injury, it's compensable, but if you have an affirmative defense, you don't get any benefits anyway. And these are affirmative defenses. The burden is on the defense to prove them. So if you can show that it was substantially caused by lawful, non-discriminatory, good faith personnel actions, then you win on the defense side. No benefits are due. There is pages and pages and pages written in Sullivan on comp on what constitutes good faith personnel action, but it's intended to limit the claims out there for psychological injury. And remember, substantial cause is only 35 to 40% of the psychiatric injury. So when we're talking about the good faith personnel action, you don't have to come up with too much as the defense in order to establish this defense, even though it remains our burden. What is a personnel action? And this is where it really is the rub. Obviously if it's not lawful or if it's discriminatory, those aren't too frequent though. What's more frequent is, what is a personnel action? And the big one, of course, is sending someone home, because we determined sending someone home might very well meet the definition of the causal definition required. But if it's a personnel action, then it's defensible nevertheless, right? Well, personnel action has been defined by the courts as, quote, conducts either by or attributable to management, such as things done by one who has the authority to review, criticize, demote, or discipline an employee. So transfers, demotions, layoffs, performance evaluations, disciplinary actions of any kind, terminations of employment. These are personnel actions. However, a lot of things are not personnel actions. A change in job requirements, increased workload, and stressful working conditions are not personnel actions. Just because your job's stressful is not a personnel action. Your manager's not doing something to you. A significant change of work duties without adequate training is not a personnel action. They're not training you. Work sucks. That's not a personnel action. This defense does not apply. Implementation of a new computer system. All of these are cases, there's examples. None of them are binding, but they're all examples of what is not a personnel action. So where does that leave the employer? I don't think it leaves the employer in such a good spot. I think sending someone home to work might not be a personnel action under the standard that we're seeing under the case law. Now, look, if the psychiatric injury was caused by termination, layoff, transfer, or reassignment, it'd probably be considered a personnel action. The layoffs, you got laid off, that's a personnel action. I think there's little doubt about that. Stress related to job duties, new computer systems or requirements, maintaining physical distance, probably not. Those probably are not personnel actions, and this defense would not apply. It's unlikely that we're going to fight about all this stuff, folks, for sure. Okay, it's all colorable, but it's unlikely that requiring them to work from home would qualify as a personnel action, as this is where and how a job is performed.
In the context of COVID, we've seen reports about employees pushing back on employers concerned about not being provided with proper personal protection equipment,
Mhm.
delays in getting some of that equipment. I think that all falls into a stressful work environment, and I don't think is protected by the personnel action defense. So not only talking about, when you talk about facts, you got to look at the facts that are specific to COVID-19 and what's going on daily in the workplace. And this current pandemic definitely presents some unique and interesting facts that I think probably negate the personal action defense.
Yeah, I don't know, man. We're gonna fight. I can
That's why
say
we did this one in separate locations, despite the technical glitch. It's a good thing we're not sitting across the desk from each other today, Mike.
that. Well, putting it all together, if you look at the role to analysis, which set out the good faith personnel defense, it goes through and says, like, you have to have the actual employments, you got to have the required percentage, right? If that's met, then you have to determine if it was a personnel action, whether it's lawful, non-discriminatory. If all of it's met, then you can have a defense. The board has to determine whether, that it happened, and that we need medical evidence for it too. So off it goes to the doctor, and off it goes breaking down a different, kind of talked about this, the different causes, what's an actual event, what's not. He puts it all together and decides if it's a substantial cause. So we'll have to see what happens there. The next defense is a 6-month rule. If you haven't worked, according to this rule, if you haven't worked 6 months in the aggregate by case law, then you can't have a psychological injury. Even physical injuries that result in psychological injuries you can't have a psychological injury. So that's a pretty clear-cut rule, and it has been applied pretty consistently by the courts. So you have to look at those cases. If it's caused, there's one exception, is if it's caused by a sudden and extraordinary event. Would COVID-19 be a sudden and extraordinary? If you get COVID-19, would that be a sudden and extraordinary event? That's another discussion. If you look at the case law, we have Matea, which says it has to be both sudden and extraordinary, meaning it happened without notice or with very brief notice. It's sudden. And extraordinary, it's like, whoa, look at that, going beyond what is usual, regular, common, or customary. And the nature of the injury is not determined. Again, it's not how bad the injury is, but what happened in the injury itself. Was it sudden and extraordinary? And the answer for COVID, I don't know. A good example is Oresco, where the board held that a maintenance worker who suffered bacterial infection, which manifested as Guillain-Barré, was a rare condition, did not suffer. He got sick, and he didn't suffer from an extraordinary condition. I mean, extraordinary maybe, yeah, for sure. But sudden, it doesn't seem to meet the definition under the case laws we have so far. So I'm really, in this case, Oresco, it was alleged that the applicant ate tainted food at work. But they said, look, this is nothing unusual, uncommon, or unexpected. Maybe COVID is unexpected, although it's becoming pretty common, right? So maybe it's not, but maybe it is. But is it sudden? It's hard for me to visualize a world in which, it's viewed as sudden. I don't know what you think about that, Adam.
I would tread cautiously in someone who worked for less than 6 months, but if their injuries warranted it, there may be enough facts to challenge it and make some law on the sudden extraordinary issue.
No way. No way. You're dreaming. Okay,
I'm just leaving the opportunity open.
You're doing your job, Adam. I respect that, kind of.
Thank you, sir.
Okay, so I know my approval means the world to you. So I think I did the wrong button here. And finally, we have a last defense we want to discuss is 4660.1. Now, this is what came out in SB 863 in 2012 and said, look, if you have an underlying physical injury and the psychological injury arises out of that compensable physical injury, then you can get benefits for your psychological injury, but you can't get it. You can't get it for permanent disability. There's no permanent disability increase in these sorts of cases. This was meant to limit the damages that employers had to incur for psychological injuries. I know you don't like it, Adam, but
not a fan of that law, but I don't think there's going to be a bar in these cases with respect to this particular statute. I mean, it could in some instances, but as you've noted here, I think that there's a strong argument that it's not a compensable consequence type situation. And furthermore, you could argue the psyche arises as a direct result of contracting the virus. So I'm not too worried about this being an impediment if it's necessary in a given case.
I don't know. I think this is exactly what's intended to apply to. If there's an underlying physical injury and then you get psychological damage because you have that injury, then that's what this applies to.
It's a disease.
Yes, that is the next slide. And that's,
You know,
that's
my
trouble.
law school, my
Yeah.
professor would say, read the statute, stupid. Now I'm not calling you stupid. I'm just saying that's what the professor would say.
Yeah, well, the labor code does differentiate. We have it here in two places between injury or disease and occupational diseases or cumulative injuries. So this may not be considered a physical injury. This distinction is recognized in the law and is problematic. There was one case we didn't put on here, but the guy got really fat as a result of the injury, and then he got psychologically injured because he was fat. And it was found to be an underlying physical injury. So it's arguable, but don't tell anyone, but I kind of agree with Adam. This may be considered a disease. It's certainly going to be a colorable complaint we'll argue about.
Hey, Mike, just one last point on psychiatric injuries is just to remind the listeners about the new statute, Labor Code Section 3212.15, which finds PTSD a rebuttable presumptive injury for public safety that was enacted 1/1/20. So that might be something that applies in a COVID situation for public safety.
That's a good point. We didn't talk about that one here, but that did come into effect 1/1/20, and that presumption may apply. Make it a presumption anyway. So
true. That's right. Presumptions everywhere.
We're just out of time. This is our slide telling us who we are and how to contact us. If you have any questions or comments, they're always welcome. We try to answer them after every webinar. We welcome any feedback, positive or negative, about how we did or what we said. Give us a call. If you're not a Sullivan & Comp subscriber, you're completely out to lunch and you must immediately modify your terrible, horrible judgment and decision-making process. So you can reach us there and get our book there too. Hey, Adam, thanks for helping out on these webinars. It's been a valuable contribution in a time of real need for everybody in the industry. So we appreciate it.
Thanks for having me. Be well, be safe, y'all.
Okay.
Right back at you.
Bye.